Hi, Jacques.
Hi, good evening, Rayan.
How are you doing?
I'm good this side. How are you?
Well, thanks. Shall we then get started? Okay, so you've recorded the session.
Yes, I've just started the record button. I just pressed on it now. So you're more than welcome to start, Rayan.
Okay, thank you, Jacques. Can you all see that? Good evening, everybody. Can you all see that? I've shared my screen with you there.
We can, Rayan.
Okay, that's good. Okay. So who this evening, I can recognize some of the names, but is there anybody that is here for the first time this evening? No. Okay, then. Good. So these are people that have been here before. So we'll continue, guys, with our session this evening. And what I thought we can do is to discuss the subject of dismissals, which we didn't actually really properly discuss, you know. I think we need to give that some attention. And then also I want to remind students that, you know, you're welcome to set up a one-on-one consultation with me by clicking the link that is available for that. Okay, so if you want a consultation for further assistance or for me to discuss an area of the work that you're having difficulty with, you're welcome to do that at no charge to you, of course. So, yes, we've looked at various aspects of the labor employment contract and you know, conditions under which one can work. You know, that's regulated. While you are working, you're not allowed to be discriminated against and unlawfully. Also, we have the right to fair labor practices. You have the right to safe working conditions, all these things. But what happens when you reach the end of the employment contract? And you know, what are the ways that this contract can come to an end? And that is what we will discuss and you know, explore this evening. Feel free to ask any questions as we go along. Now, we did an exercise. I think I don't know if it was this class, but we did a exercise on dismissals, but not perhaps this one. And so, for your consideration this evening, we can work around this little topic here. Okay, and it's a scenario. So, after having been on maternity leave for 4 months, Alice returns to her workplace to start working again. On her return, her employer tells her that the job is not available anymore, as he had to employ someone else to take over her duty. Okay, so according to the employer, Alice was only entitled to 3 months maternity leave in terms of her employment contract. And when she did not return after the 3 months, she had the right to appoint someone else. Alice is now effectively unemployed. Okay, now there's a lot of litigation in respect of unfair dismissals that arise out of the subject of women getting pregnant and the complications that arise work-wise, not with the pregnancy, but work-wise. You know, where employers feel that you know they really feel the punch or the difficulty when someone who is employed is gone for a while and they need to now make a plan when that person is gone. So, what does the law permit and what does the law allow? Now, the first question that's put is, do you think Alice's employer is able to dismiss her due to her taking 4 months of maternity leave? What do you guys think? Can the employer, is anything wrong with the way the employer treated Alice in this situation? If so, what do you think it is? Well, from the employer's point of view, he's going to argue that, look, you signed an employment contract with me in terms of which I permitted maternity leave up to 3 months, and doesn't tell us more than that. 3 months before, 3 months after the date of the birth. What does that mean? So he's going to start off there with, you signed a contract. It says that you will only get 3 months. In her absence, he had to get somebody else, and he no longer can, take her employer now. So she can't resume work now. Okay, anybody? Do you think this is fair to her? Is it proper? Yes, Mr. Ramova, yes.
Hello, Ryan. How are you?
Well, and you, sir?
I'm good. I think it is unfair because what I know, the maternity leave is 4 months, not 3 months.
Okay, good. Just hold that point there. Very good point. So the first thing we've picked up here is that, hold on now, 3 months is below the required minimum allowed by which law, which act tells us that it's 4 months.
What I know, Ryan, is that I'm working in government. And what I know is...
You come across this all the time.
Yeah, what I know is that maternity leave is 4 months, not 3 months.
Yes.
Yes.
Now,
and I understand it was also agreed on the triple SBC.
Triple SBC, yeah? Which bargaining council is that?
I understand it's representing all the labor unions which are registered with the labor department.
Okay. Well, that's in government. So, yes. Now, so the thing is, we have a contract here. In this example, we now have a contract where the parties have apparently agreed to something which the Basic Conditions of Employment Act doesn't actually permit. Right. So this is not therefore, because the Basic Conditions of Employment Act says that the basic things that you may agree to are the following, and it is quite clear on maternity leave. Maternity leave is 4 months. An employer can agree to give you more than 4 months maternity leave, but cannot agree to give you less than 4 months. Okay. And what Mr. Ramova has said is that in government, where there is large numbers of employees who are represented by trade unions, who will then enter into collective agreements with employers across the board, and they will even agree to things at that level so that all employees will benefit from it. But even in that collective agreement, they can't agree to less than the 4 months that are stipulated by the Basic Conditions of Employment. So here's a problem here from the get-go. That is already a term here now that is not compliant with the Basic Conditions of Employment. So fine, that is one point. But now, can he dismiss her for taking the 4 months? That is a different question now. What law regulates dismissal? Okay, So what I'm going to do is this evening, let's read these questions and we'll go through some slides and we'll revisit this question. Okay? So the question, you keep it at the back of your mind, we'll come to it again later. Do you think Alice's employer is able to dismiss her due to taking 4 months of maternity leave? Okay. Do you think she was fairly dismissed? Do you think Alice should have a right to recourse against the employer? Okay. Perhaps we should put another question in there which says, if you do think she has a recourse, exactly what kind of recourse will she have? Okay. So the subject here is it's about dismissals. Now, what is dismissal? Okay. Dismissal is basically when the employment agreement comes to an end, either with or without notice by the employer. So the right that we have as employees under the Labor Relations Act is that every person, or every employee rather, has the right not to be unfairly dismissed. Okay, you have the right, this is a right as it is stated here in section 185. And a dismissal, we're going to come to the definition of a dismissal shortly, works in such a way that it can either be fair, doesn't mean you cannot be dismissed at all, but a dismissal can be then fair, unfair, or automatically unfair. And we're going to unload these or unpack these terms. Now, how it works is that once you have been dismissed, okay, and we will see all of the types of dismissals, but once the employment agreement comes to an end by virtue of the employer terminating the agreement, either in writing or otherwise, or by the actions even, then you have been dismissed. You then may take this matter further. You may take this matter to the CCMA or to the bargaining council under which you fall. And you would have to prove two things. Get there, you will have to prove, number one, that you're an employee, all right? And that is why such great people have gone to great lengths, some employers to get people out of the definition of an employee. The definition, the difference between an employee and independent contractor. So once you can confirm and you can show that you are an employee, and further that you were dismissed, this is all you need to do if you've been dismissed, is to prove that you're an employee, number one, and number two, that they unfairly dismissed, or that they dismissed you. And once you prove that, the law moves then the burden of proof onto the employer to show that the dismissal was fair. And when we speak of a fair dismissal, there's two aspects to this. A dismissal must be both substantively fair and procedurally fair. Now, what do you guys understand by substantive fairness? What does it mean that you can only dismiss me, or for substantive reasons or substantive grounds? Well, this means that the employer must have a reason to dismiss you. The employer cannot dismiss you without any reason. Okay? If an employer simply hands you a notice and says, well, here's a letter to inform you that your employment services, the contract has been terminated and that you should leave at the end of the month, you give them 30 days notice, and they will pay you out whatever they owe you, that in effect would not be a fair dismissal because it would be substantively unfair. Meaning no proper reason was given. No proper reason was given. And furthermore, in addition to being substantively fair, you must also follow a fair procedure. The dismissal must be procedurally fair. Okay, give you an example. You catch one of your workers stealing money, if you're an employer, and you catch one of your workers stealing your money, and you are very angry at that worker, and you tell that worker to leave immediately and never to come back. Okay. Now, did you have a reason to dismiss him? Yes, you did. Right? He committed a theft, which is a very clear form of misconduct. But the thing now is, if you didn't give him a fair hearing, technically speaking, he can take you to the CCMA and say, well, I was dismissed, yes, because I didn't get a disciplinary hearing. And because you did not do that, the dismissal is therefore unfair, because you did not follow a procedure, even though you had a good reason to dismiss that person. If you fail in either respect to dismiss somebody, the dismissal will be unfair. So you need to ensure for a dismissal to be fair that you have done it both for a good reason, and you have followed a fair procedure at that. Any questions? No. So what is this meaning of dismissal now? We need to always have a closer look at it. Section 1, and there's nothing better than actually looking at the Labour Relations Act to tell us what this means. And dismissal, as it is stated in the LRA, is it means that Section 1, this is Section 1 of Section 186. Subsection 2 deals with unfair labour practices. That will tell us what unfair labour practices are. But we're not there now. We are here focusing on this unfair dismissals and the meaning of a dismissal. Whether the dismissal is unfair is another question, but just to be dismissed, it could mean this. An employer has terminated a contract of employment with or without notice. This is very common. They can terminate you either by telling you, here's the letter to terminate you, to inform you. They can tell you verbally, thank you, don't come back. Or they can lock the doors to you. They may not have said anything, but what happened in our example with this lady that went on maternity leave, she came back. They didn't tell her anything except to say that, man, your position has been filled. So clearly it implies that she has been dismissed, okay? With or without a notice. B, dismissal means that an employee reasonably expected the employer to renew a fixed term contract of employment on the same or similar terms. Right? But the employer offered to renew it on less favorable terms or did not renew it. Okay? This was that famous reasonable expectation ground. Okay, and this is quite common as well. It has also gone through some changes over time. When somebody employs you for a year and, you're treated almost like an employee, the year ends and they renew the contract. There was in many cases like this, people working for large companies, large concerns, big businesses, and the contracts get renewed. And the employer is actually trying to make it appear that the person is not an employee but an independent contractor. But if this goes on and you are treated like this, you have and a reasonable expectation should follow, but the employer either doesn't renew the contract with you or says, I'm going to renew the contract, but I'm going to pay you less. Okay, or I'm going to give you less work hours, or I'm going to something that will give you less favorable. That is also a dismissal. And as we know, a fixed term contract is an employment contract in terms of the Labour Relations Act. Remember the classifications of all the kinds of employees. Now, Section 200A of the Labour Relations Act says that anybody who works for more than 3 months in a fixed term contract is presumed to be an employee. Okay, so this has gone through some changes. That change came in about 2013, 2014. That Section 200A to the Labour Relations Act, where this presumption of employment applies, and also Section 86, capital A of the Basic Conditions of Employment Act, where there's this presumption of employment that If you employ somebody on a fixed term contract of longer than 3 months, and you automatically deemed to be an employee, and that the employer, you deem to be an employee if one of these certain things that are present that will have to apply for you to be considered an employee, and then the employer must show that it is not true that you are an employee but only an independent contractor. And the employer will have to now prove that the person is not an employee. Okay, so but if this happens, your contract doesn't get renewed, and you reasonably expect it to happen, and you can very well reasonably expect it to happen. Even if it goes beyond 3 months, you deem to be one, and you don't have to prove anything. It is the employer that must prove it. C, an employer refused to allow an employee to resume work after she, 1, took maternity leave in terms of any law, collective agreement, or her contract of employment, or 2, was absent from work for up to 4 weeks before the expected date, and up to 8 weeks after the actual date of the birth of a child. So now if we look at our question again about the fairness of, what was this lady's name there, the question, Alice. She went on maternity leave for 3 months. She went for 4 months. The contract said it was 3 months. So now, do you think that Alice's employer is able to dismiss her due to her taking 4 months of paternity leave? In other words, is it substantively fair now for him to do that? According to section 1861C, if you do that, if an employee now is not allowed to take work, this would be a dismissal now. It amounts to a dismissal. But still, we haven't decided whether it is fair or not. All we know is that this is definitely a dismissal. Okay. Now, remember we spoke of a dismissal can either be fair, it can be unfair, or thirdly, it can be automatically unfair. Now here, section 186C speaks very clearly about that position of someone who is pregnant and, goes to, has been dismissed because is not allowed to take up work, after she took a maternity leave, will be what will happen to her. So there's another section 187, that speaks of automatically unfair dismissals, where it is very clear the person has been wronged. Okay? And we will come to that in a moment, and we will see whether it applies to this case here of Alice as well. We're quickly going through the list of meanings of dismissals. D, an employer who dismissed a number of employees for the same or similar reasons has offered to re-employ one or more of them, but has refused to re-employ another. Okay? I'll give you an example of that in a moment. An employee terminated a contract of employment with or without notice because the employer made continued employment intolerable for the employee, the so-called constructive dismissal, where you're not dismissed by your employer, but you leave and you terminate the contract, but you did it only because the employer had made your work, further work, intolerable for you. And then lastly, this has to do with when a business is sold or transferred. Okay, when an employee terminated a contract of employment with or without notice because the new employer, after a transfer means like a sale or a change of ownership of the business, provided the employee with conditions or circumstances at work that are substantially less favorable to the employee than those provided by the old employee. I'm going to give you some examples of that. So yeah, a refusal or failure by the employer to renew a fixed term contract, we gave that example, right? We just spoke about that. Maternity leave, he was to be busy with this one right now. An employee will be considered to be dismissed if she is not allowed to continue work for maternity leave. And the Basic Conditions of Employment Act has 4 months. selective re-employment. Now, let me give you an example here. This is where, say, for example, an employee here dismisses 3 of his employees for theft. They've been stealing, and they have a disciplinary hearing, and they then find that they are guilty, and they dismiss all 3 of them. And they have to leave, and after they leave, the employer calls one of them back, but he doesn't call all 2 of them back. So this would amount to a dismissal. Okay? Whether it is fair or not, it must also be the employer has to now prove that it is fair, why I did that. But if you selectively re-employ some workers and you don't others, it is considered a dismissal. Okay? And the employer must be careful. If the employer can't justify it, possibly he can justify it if he had like the hearing in terms of an operational requirement. In other words, where he dismissed workers for operational requirements and said, well, I can't keep all of you because of financial, economic, structural, or technological changes in the business. And we had to restructure, we had to scale down, and therefore some workers had to go. And we could only then afford to re-employ 1 or 2 of them, and not all of them. But if you don't have a just reason for it, you cannot selectively re-employ people that you have dismissed. Okay? Otherwise, you will have a difficulty as the employer to have to prove why it was so. Constructive dismissal. This is where there is no dismissal, of no termination of the contract by the employer, but rather by the employee by resigning. And this changes the onus of proof a bit, because in normal dismissal matters, unfair dismissal matters, the employee must prove that he was an employee and that he was dismissed, and then the employer must then prove that it was fair. In such a case, you leave the employment, you resign, and therefore technically if you resign under normal circumstances, can you hold your employer responsible for that? If you resign, even if any of you who are working resign tomorrow, will that be a reason for you, your mere resignation, for you now to hold your employer responsible for that? Anybody?
No.
You're right, Grant. You're right. I mean, under normal circumstances, there's no way that when you resign, when you terminate the obligations here, when you terminate your contract with resigning, it's not normally the employer's fault. I mean, unless, now that's the whole thing here. Section 186 1E is an exception to this. Okay, you're leaving not because you want to, you're leaving because the employer is making further employment intolerable for you. Now, it may not particularly be clear, but just think about this for a moment. What happens if it's a woman at work and she gets harassed, abused or something like that, right? So the law doesn't expect you to keep up with it. It would be dangerous for the woman even. So for her to leave and then take the employer to the CCMA afterwards to prove this. The only difficulty is this, that you as the employee who resigns must now have the onus of proving that the employer made it intolerable. Okay? And intolerability is an objective test. What is tolerable for one person and not necessarily intolerable for the next. So it's an objective test where they compare your conduct with that of a reasonable person. Okay, because then everybody will start to resign tomorrow and take the employers to the CCMA and hope, in the hope that they can get some kind of compensation out of them. And naturally, before you invoke it, before you resign, you must also show the CCMA, where you require to show that the employer's behavior was such that it made further work intolerable, that you attempted to resolve the matter between yourself and the employer, through perhaps through a grievance procedure that was continually ignored. There is other things that you must try and do before life becomes intolerable for you. Okay? If you're working at the place and they expect you to wear a red cap every Friday from 9 to 12, because it's the manager wants you guys, or the boss wants people to do that in line with his sales marketing gimmick, and you feel that wearing a red cap, every Friday from 9 to 12 is intolerable and you resign, that won't fly. Okay? From the case law, we know that what is considered intolerable are things like harassment, assaults, continuous abuse, failure to pay. Of course, I mean, that is the ultimate, one of the most potent reasons not to leave is when you're not being paid. And assisted many people over the years who have resigned, and have been working elsewhere, and yet afterwards even were successful with constructive dismissal referrals, but because they could prove that the employer had made life intolerable for them. Of course, there's another thing that you could do if you are working and you don't desire to resign. Can anybody think of the procedure or remedy for somebody who is working and the conditions are not ideal, but you don't wish to resign, but yet you're working and they're not threatening to dismiss you, but is there anything that you can do when you're working under conditions that are, when you are working and you're being treated in such a way where the conduct is what we call short of dismissal? Anything short of dismissal? Is there anything that you could possibly do here? I mean, the employer's conduct is such that, it involves conduct that is just short of dismissal. In other words, short of dismissal, they're not dismissing you, but it is practically as if though you're on the line and the edge every day, treatment that you're getting. Yes, Grant.
Should they lodge a complaint at the CCMA?
Yes, they could, but now there must be a reason, there must be a particular basis. You see, there's a number of things that you can take to the CCMA, but you must have the particular, in labor law, we want to know exactly why you're referring it. You can refer a number of things. So if you're going to refer it, what are you going to refer it as? Where the conduct complained of is short of dismissal. Okay, so this is basically an unfair labor practice. Okay, when it involves unfairness on the part, any act or omission on the part of the employer that is short of dismissal. That is mentioned in section 1862B. Unfair suspension or any conduct that is short of dismissal. So a short of dismissal, they're not dismissing you, but they're treating you so badly in such an unfair way that you're just about hanging on, but they're not dismissing you. So you have a remedy there instead of resigning, which is an extreme example, extreme action, and one must be careful with that. But there's no guarantee, of course, that if you resign and you can't prove all those other things of intolerability, that you will end up in difficulty there. You could refer it as an unfair labor practice. And the unfair labor practice is a dispute about unfairness on the part of the employer involving a number of things like promotion and demotion, but The point is you're still employed. It's not like you dismissed. When you come to the CCMA for an unfair dismissal, it means you have been dismissed already. But for an unfair labor practice, while you're taking your employer there, you're still being paid, you still have to work, and if it goes in your favor, it's not like they can dismiss. Well, okay, let me ask you another question. What happens if they, because you exercised your right, or under the LRA, as an unfair labor practice, and your employer didn't like it, because they think, oh, this is a smart aleck, he wants to take us to CCMA and here and there, and now they start to prejudice you. They treat you indifferently, and they give you further bad treatment, or they even end up dismissing you because of it. Then what? Okay, we'll think about that for a moment. When we come to the subject of automatically unfair dismissals. Okay, and in the last category of these dismissals here is an employee being provided with less favorable terms after the transfer of a business. Now, this is where a business gets sold, okay, either as a going concern in terms of section 197 or 197 capital A as a business that has gone into liquidation. Okay, so if you now are going to be employed by a new person and that person gives you less, they change your hours to more hours, they change the pay, this is considered a dismissal as well. These are the examples I spoke about. Failure to renew the fixed term contract, we've been through this already. The reasonable expectation and so forth. But as we know, this has changed somewhat due to section 200A of the Labour Relations Act that presumes employment and puts the onus on the employer to prove otherwise. As we also spoke about, this is where when you have people that you dismiss and you decide to re-employ only one out of the people, not all of them, so that selective re-employment becomes a dismissal as well. Okay, but it will have to be proved by the employer to show that why you did it, why you didn't employ the other people instead of only the one or two, is because of justifiable reasons. Okay? But in itself, to selectively re-employ people is a dismissal. So this current example we're talking about when the business is sold or transferred, and they cannot be on the whole less favorable than like it was before. And if they are, you don't have to put up with it, and you can also claim constructive dismissal afterwards. Before I continue, are there any questions? You guys are rather quiet this evening. That's everything cool?
Prof, I'm just letting you know that your voice does go away from time to time, which interferes with following your on what you're saying.
Is that so? Oh, I'm sorry about that. Let me just see if I can resolve that issue. You see, I'm speaking into my laptop and my laptop speakers. So, okay, perhaps I must just hold on a second, will you? Okay, can everybody hear me now?
Yes, Ryan, we can hear you.
Is it better now?
Yeah,
I
it's
don't
better.
want my voice to
Much
go
better.
away from.
Much better.
Okay, so what I did was I had to, unhand a set of earphones from my son and plug it into the laptop, yeah, instead of speaking into the open speaker. Okay, that's good. So now, where were we? We were talking about, before we went to automatically unfair dismissals, we were talking about what were we talking about? We were talking about the various kinds of dismissals, and we're dealing with the less favorable terms when the business is sold, right? And you can claim to constructive dismissal. And now we will deal with automatically unfair dismissals. Like we said, there's three kinds that you can distinguish if you actually look at the section on, on this chapter of the LRA that deals with dismissals. You have the right not to be unfairly dismissed. It's a right in itself. Every employee has the right not to be unfairly dismissed. And therefore, provision is made for what is called a fair dismissal, an unfair dismissal, and an automatically unfair dismissal. So how's an unfair dismissal and an automatically unfair dismissal different? So an automatically unfair dismissal is particularly, prescribed in Section 187 of the LRA. And why that is there is to very, succinctly give a remedy to an employee who's got his right is clear and the infringement of his right has been clear. Okay, there's not much that has to be, one can easily determine that that person falls in that category. Okay, unless there's only an exception to it, and that is if the person is, the job is an inherent requirement of the job, why this person was dismissed, or the person has reached retirement age. Okay, otherwise, if these circumstances are there, then the person automatically would be considered to have been unfairly dismissed. And the thing with automatically unfair dismissals, as opposed to simply unfair dismissals, is the quickness of the remedy, of course. It's been clearly prescribed there. And secondly, what would happen to the employer now? That if it is found that an automatically unfair dismissal case has been made out, then the employer may be ordered to pay up to double the normal compensation in terms of salary. For an unfair dismissal, the Act limits compensation to be paid up to a year, that's 12 months. But for automatically unfair dismissals, you could be paid up to 24 months, double the amount, which is punitive even. Okay. Any questions on that? Nothing. Okay, so we move on now to examine what those specific cases of automatically unfair dismissal are. We dealt with what dismissals, constitute, Section 186. And what we described there was not unfair dismissals, but what a dismissal is. Whether it is fair or not must still be determined, okay? But and fairness is both substantive and procedural. So what is an automatically unfair dismissal? So it says here, a dismissal is automatically unfair if the employer, in dismissing the employee, acts contrary to Section 5, or if the reason for the dismissal is. Now, Section 5 has to deal with organizational rights. Okay? The organizational rights of forming a union, participating in union activity, creating a bargaining council. You know, that's what Section 5 of the LRR deals with. But here in Section 187, it says here that A, the employee participated in or supported. Just read this carefully. The employee participated in or supported or indicated an intention to participate in or support a strike or protest action that complies with the provisions of Chapter 4 of the LRA. So now here we can see how very strictly the laws, Section 23(2), Section 23 of the Constitution, those rights to, you know, to associate, to form unions, to organize union activities and programs, and to strike and to, you know, protest and picket, all these things. If you do, even if you indicate an intention to participate in them to your employer, and you are subsequently dismissed for that, it will be considered to be automatically unfair. So therefore, how deeply entrenched is you know, not students, but employees' rights to participate in these activities. So it's a constitutional right, comes from the Constitution, and it's further entrenched in the LRA. So an employer must be very careful when it deals with strikes, striking workers. You can't dismiss a worker who participates in a lawful strike. Okay? There's two questions here, as you should know. The strike must be lawful. If you are participating in an unlawful strike, then you stand the risk of facing disciplinary action and possible dismissal. And what did we say? We dealt with strikes in that before. We said that what does it require, you know, how can a strike be declared lawful? What must happen for a strike to be declared lawful? All right? The workers and the unions need to, you know, engage the employer in matters of mutual interest, and they must try and resolve the matter. And if they're unable to resolve the matter, they need to refer it to the CCMA for conciliation. Okay? Or they need to follow what they have agreed in a previously signed collective agreement between them. And most often, the collective agreement has to refer the matter to arbitration. So they can't go beyond what the LRA says in terms of the procedure. You know, they can't deviate fundamentally from this procedure in Section 64 and 65 of the LRA. So they need to go to arbitration. They must try and come to an agreement on this matter of mutual interest. It must be a matter of mutual interest. And if the employer refuses to negotiate with them, or, you know, then the arbitrator can give what is known as a certificate of that the matter remains unresolved. Or even if they are negotiating and they can't settle and 30 days go by, then the arbitrator should give the certificate that the matter remains unresolved. And if either of these happen, then a party may give notice, you know, up to from minimum of at least 72 hours to the employers that they intend to strike. And if it is the state, it's longer, something like 7 days. So the employer in the same rate can also inform them that, well, if you're going to strike, we will be locking you out. So if that has all been complied with, and they then, you know, participate in or any of these things, they then have the protection and they can't be dismissed. And if you dismiss them, it would be automatically unfair. Another thing that happens that when people go on strike, not every single employee strikes. There will be some employees who will not participate in the strike. They may even continue working. And the employer then sometimes is pressed with a few employees he's got to continue some of the work. and he may even get along with getting the work done with the few that he has, those that don't go on strike. But even those people who are not on strike, but then when they are demanded by the employer to do certain things or work that is normally done by the people who now are on strike and they refuse to do it, they can be, and they get dismissed because of it, that is also automatically unfair. Unless that work is, of course, an emergency type work, okay? So refusing this ground of automatically unfair dismissal is non-striking workers not doing the work of the striking workers when demanded by the employer to do it, and they refuse. And the refusal is led to their dismissal, it would be automatically unfair. Okay. C, to compel the employee to accept a demand in respect of any matter of mutual interest between the employer and the employee. Now, again, another matter that falls in collective labor law. Now, remember, a matter of mutual interest, it's mentioned all over the LRA. It is a matter that the law allows and encourages both employer and employee to rather sit down and negotiate about and come to an agreement on. Okay, so it could be things like working conditions, things like pay increases, and so on. But during this time, it's a volatile time, you know, so the employer may say to them, the employees may say, we want a 20% increase. The employer will say, well, I'm giving you 12%. And if the employees refuse, the employer is going to say, well, if you're not going to accept the 12%, then I'm going to dismiss you. Okay? If they try a trick like that, that in itself is also an automatically unfair dismissal. And then D, this is the interesting part here, guys, that the employee took action or indicated an intention to take action. So you may not even have done it actually, but you may have said that you're going to do it. So the employee is going to take action against the employer by 1, exercising any right conferred by this act, or 2, participating in any proceedings in terms of this act. Now that is so very broad. It's almost what we can call a catch-all clause to protect and to cover basically all actions under the act. And what do you get under the act? You can get unfair labor practices, you can get unlawful discriminations, you can get all these industrial action rights, like, you know, striking, protesting, picketing. So if you use the act, if you unfair dismissals, if you are, you know, dismissed simply because you feel you're exercising any right under the law of the Labor Relations Act, and you can prove this, then it would also be considered an automatically unfair dismissal. Far-reaching clause and covers a lot. If you can prove your case, the employer is in trouble. And you do hear stories of employees saying they feel intimidated by the employers, they don't want to lose their jobs, etc., etc., because they feel victimized if they do it, and they end up even losing their jobs. They're getting dismissed for it. So there is protection, you know, for that by those actions of the employer. Can you all still hear me?
Yes.
Loud and clear, sir.
Okay. That's good. So E, the employee's pregnancy. There we come up to that thing of Alice. The employee's pregnancy, intended pregnancy, or any reason related to a pregnancy is an automatically unfair dismissal. So think about that now. Alice, she went on maternity leave. She signed a contract, right? She signed a contract that said she's allowed 3 months. She was away for 4 months. She comes back, the employer tells her, no, we got somebody else. So how wrong is that not? She obviously was unfairly dismissed here. Okay. And not only unfairly dismissed, would you say that it was so?
Yes, right.
Yes. So imagine that now. 2 years, 2 years of salary you could get. And you could insist that you also be reinstated. You know, that is one of the reliefs that you can. So reinstatement is in addition to compensation. So if the person is there, provided the employee and the employer want it, of course, they've got somebody else there now, and that will make it very difficult, but the maximum is 24 months. That the courts may order, you know, the compensation to be paid. Okay. What else is automatically unfair? The employer unfairly discriminated against an employee. Okay. So again, this needs to be read together with which other law? Is there another law that also speaks of unlawful discrimination? Well, there's a couple of laws, but I'm thinking of one in particular that affects labor law. What would that be?
Employment Equity Act.
That's right. Employment Equity Act actually mentions these grounds. These grounds are also mentioned in the Constitution, Section 9, the Equality Clause, that discrimination is not allowed. There's also another law called the Prevention of Unlawful Discrimination. You know, an equity, a Promotion of Equity Act, which is promoting unlawful discrimination, promoting fairness and equity and preventing discrimination outside of the employment sphere. The Employment Equity Act deals with unemployment. You know, sphere is the Employment Equity Act that deals with you know, specifically discrimination in the workplace. Okay, and also deals with affirmative action. But look, if you can prove that you are unlawfully discriminated against, it is also an automatically unfair dismissal. Then transfer or a reason related to a transfer contemplated in section 197 or 197A. Now that is both a dismissal, and now we can also see an automatically unfair dismissal, where the transfer relates to, and remember when the business changes ownership now, or is transferred as a going concern, the new employer cannot give you less conditions or less favorable conditions when they take you up. And if they do, you may resign and take it up as a constructive dismissal, or you can just refer the matter to the CCMA on those grounds. And lastly, a contravention of the Protected Disclosures Act by the employer on account of an employee having made a protected disclosure as defined in that act. Now, this we dealt with in the recall. If you guys can recall, we had an example of an employee who was working at a construction company, and every month the employer deducts UIF from their salaries. But what the employer does is he's supposed to pay that money over to the unemployment insurance fund, but he does not, but instead uses it for personal reasons or for his own expenses. And this employee finds out about this, and the employee refers the employer to the authorities, reports it to the Department of Labor. Those are the parties that are entitled to receive the monies. And the employer now is unhappy with this behavior and puts the employee on suspension. That was the one thing we discussed. But either way, then in the context of the discussion, we referred to the Protected Disclosures Act, and we said, well, there's a particular law. There's another little nickname given to this law. What is it called? It's a nickname that people give to the Protected Disclosures Act. the Whistleblower Act, guys. Remember, this is a law which says that it defines what is a protected disclosure. Okay, so a protected disclosure and a general disclosure. It makes different. It defines these two things. And a protected disclosure is information that basically, or things or activities that amount to almost crimes, basically, at high level. Either crimes that go against a particular law. Like, for example, if you work in government, you work in the procurement department, there's a thing known as the Public Finances Management Act, which regulates how the tender process must be followed. And you come to know that, the person in the tender department is a high-ranking official, and he is busy doing things that is, illegal, perhaps taking bribes, or he's doing things that are flouting it. And you know that if you were to report him, that you yourself would now get into trouble. You would suffer what the Act calls an occupational detriment. An occupational detriment is either you're going to be dismissed, or you're going to get a demotion, or they're going to transfer you to to another department, or you'll suffer some kind of prejudice known as an occupational detriment. And to be a protected disclosure, it must be a law that has been broken, like a crime, or by a high-ranking official, like a minister, or even a legal advisor, or something in that context. Okay, because we have to be careful when we make disclosures. You can disclose certain things that are not. Some things are not considered protected disclosures, but there are, general disclosures which don't fall into that definition. Okay, so you must be very sure that when you accuse somebody and you even report them, that you must have the evidence to prove it. You must have at least have the likelihood. You must have a reasonable belief that it is true. Okay, because you could be wrong in your belief, and then therefore you yourself could be guilty of misconduct. Okay, so when you do something under the Protected Disclosures Act, where you are suffering an occupational detriment or will suffer one, if you make a protected disclosure, and if you have made one, you will now get dismissed for that. It will be an automatically unfair dismissal. Are there any questions on this, guys? Okay.
Prof?
Hello,
Can you
yes,
hear me?
who's that? Yes.
It's my Benat.
Yes, my Benat.
Yes, Prof. I'm so sorry if I'm going to take you back, but I'm gonna ask a question in relation to Section 187, subsection 1, paragraph G, the 197 related automatic unfair dismissal cases.
Just one second. Yeah, let me get there quickly.
Yes.
187G.
Yes, G.
Yeah, the transfer, yeah?
Yes. Okay. I'm just going to give you a scenario which many employees normally face from our perspective as trade unionists. You would find that an employee, in fact, the company has been transferred as a going concern in terms of Section 197, and there are these changes that has taken place as a result of, that had taken place in terms and conditions of employment by the new employer. But these employees continue to do their job. So the question is, if that is regarded as an unfair dismissal, or maybe regarded.
Okay, yeah, it's regarded as a dismissal, right? That is regarded as a dismissal. Whether it is fair or not now, is now must be shown by the employer. Okay. But now,
my point is, these workers are continuing to do their work. So can they refer a dispute of unfair dismissal whilst they are still working and this dismissal to me is it's a technical dismissal, but they are still working. So could
I
they
would say
refer
yes. I
dispute?
could say yeah. You see, the thing is, because you look how that has been phrased. Let's go there quickly. In section 186. So we look at that. So an employee terminated a contract with or without notice because the new employer, right? So if they are still working, I see your point, because here it is saying that you are, as the employee, are terminating, just like in the constructive dismissal scenario, you are terminating. So when you terminate, you go, all right? And you are now lodging a constructive dismissal matter now under section 180, saying, well, we got less conditions. So those people, it won't be a dismissal then, but because if they leave, they wouldn't be able to invoke it. You understand? This is the difficulty with it now, that they won't be able to invoke this as a dismissal, as an unfair dismissal, because they're continually working there. To invoke it, you would have to terminate the contract. You would have to resign. Right? What they could do, they are playing with a bit of fire here. If they are, in the sense that if they're going to submit their notice now of resignation, what they can do is to say that, okay, I'm resigning, and I'm referring this to the CCMA. It's an automatically unfair dismissal, and ask for reinstatement at the same time on those same conditions. You understand? On the new conditions, that look, I had these conditions, like you told me. Now you have workers working and that were working with the old employer, and they were receiving certain benefits and certain working conditions. Are you there? Can you hear me now? Right. So here, what I would suggest they could do is they could resign, right?
Yes.
As a constructive dismissal in terms of section 186(1)(f). Right. And when they go there, they will have to prove that it was unfair, but it could very well be an automatically unfair dismissal. One can also ask for reinstatement. So this is a time for them that they can take it for constructive, refer it as a constructive dismissal. It will be referred as an automatically, an unfair dismissal as well, because it falls under, it involves a transfer in terms of 197. They can get the maximum compensation possibly, and then at the same time also ask for reinstatement.
I've
but
got
there
it.
is that risk. That risk is that, once you leave, who knows? It's no guarantee that the court may also do that. We will learn in a moment also how automatically unfair dismissals get heard and where they get heard. Okay. The best thing to do in such a case is to file a grievance. They must file grievances with the employers. So look here, you people are, you need to address this issue. What the employer will do then is also then start operational requirements hearings. You must understand, the employer will start to say, well, I can't keep you on if you want to be maintained at that level. You understand? And the employer will justify and try and make that dismissal fair. That is, I'm just trying to tell you what could possibly happen. That the employer will see that, okay, these guys want more, we can't give them. So once they see that, the employer's HR people or their lawyers will institute operational requirements hearings, and to try and justify why they're paying you at a lower rate and at a lower benefits. So best thing is to try and resolve it internally with your employer, and try and come to through a grievance procedure. But if your mind is made, nothing stops you from exercising these rights. You know, I'm just trying to think if section the unfair labor practice could fall in this, but unfair labor practices are, you know, you could refer it as I doubt it will fall under that, as a demotion maybe, you know, that you've been unfairly demoted now by virtue of this whole thing happening like this. And at least with the unfair labor practice referral, you don't leave your employment. You know, with a constructive dismissal, you actually terminate, you resign, and that is a bit you know, risky there. All right. I hope that is can shed some light on that issue there. Now, okay, so dispute resolutions. Now, how does it automatically unfair dispute resolution get resolved? A normal automatically unfair dismissal gets resolved in such a way, right? You get dismissed, right? And then within 30 days of being dismissed, you must refer it to the CCMA. Okay, if you're late and you've got a problem there, you must ask for condonation. But let's say you've filed your referral within the 30 days and you set the matter down for conciliation, mediation, and you hope that it can be settled through conciliation or mediation, okay? If it doesn't work out through conciliation or mediation, it gets referred to arbitration. And this is how a normal unfair dismissal matter is heard. Okay, it gets arbitrated there at the CCMA or at the bargaining council. After it has been arbitrated and an arbitrator has made an award, there's very little that you can do except to take that award on review. You can't appeal that decision. Labor or CCMA or bargaining council awards by arbitrators are almost like final. They cannot be appealed. One can only take them on review in the labor court. Okay, and that is a bit difficult to do. The law has changed to make it very difficult for you to take those decisions of arbitrators, you know, at the CCMA on review. It's very limited grounds, like gross misconduct, bias, you know, impropriety, and things like that. Acting beyond the scope of their powers, which is, you know, from the case law, it's showing that it can only do that under very narrow grounds to review the award of a CCMA arbitrator. But with automatically unfair dismissals, it's different to a normal unfair dismissal. You know, after a point, you go to the CCMA within 30 days, you put it down for conciliation. If you can't conciliate, if it gets conciliated, the matter is finalized. If it is not conciliated, you don't go to arbitration, but you instead go to the labor court. So the difference with this is that it gets finally decided not by the CCMA, but by the labor court. Okay? And that's a bit different to the CCMA. The arbitrators there, it's a formal court. It ranks the same as a high court, you know, and it's the costs to run the thing there is also costly if you're going to use a lawyer. And if you're not happy with the labor court's decision, you can take it to the labor appeal court, which is in Braamfontein. And that court is the highest court in all labor matters. Right. And we said the only thing that can justify an automatically unfair dismissal I repeat again, is that it must be an inherent requirement of the job, and that either the party reached, old age or pensionable age, as is agreed between them, or is required in terms of a contract. Okay, so now what is considered fair in terms of the LRA? We mentioned that you can only dismiss people, and what the LRA considers to be fair, on 3 basic grounds. One is where it is for misconduct. The other ground is incapacity, and the third ground is operational requirements. So your dismissal from an employer's point of view is such that you must prove that the dismissal was fair on one of those grounds. Okay. The law has not entrenched your right as an employee to not be dismissed unfairly for nothing. Okay. The law and the economy, and it requires, and people need their jobs to be secure. A job is a very valuable thing, and the law realizes that and wants to give people that assurance that a job cannot be lost so quickly once you acquire it. It is very easy to hire somebody, but very difficult to have them dismissed. And when eventually people do things that justify the termination of the agreement, okay, that they do so in a progressive manner. If it's for misconduct, which is basically you breaking a rule in the workplace, subject to other rulings and limitations, that you should be disciplined, yes, but not with the ultimate disciplinary tool, which is your dismissal, cutting off the ties and ending your job, firing you, but rather to try and progressively discipline the workers. Okay, we don't work on that system, and therefore, even when it comes to misconduct, it is certain requirements that must be met before you can actually say, yes, there was a good reason to dismiss the person. Okay, so now let us quickly look at the question of misconduct. Okay, so it's misconduct, as it says, that something that you did wrong. You broke a rule, in the workplace. And there's a number of questions that must be asked, that a court will ask, that an arbitrator will ask when it must decide and determine whether a rule has been broken. They will examine that rule. Okay, and there's many rules in the workplace. But now it will ask these questions. Did the employee break a rule or a standard regulating conduct in the workplace? So did you break a rule? Right? Then they will ask, was this rule valid and reasonable? Now, you as an employer, you may have your rules in your workplace, but your rules must also be reasonable. And that is decided by various standards of what is reasonable. The Labor Relations Act refers to the International Labour Organization's codes on reasonableness in the workplace as well. Okay, but although we've adhered to those codes, it will always be subject to the Constitution. Okay, you can't have a rule in your workplace that goes against the Constitution. Okay, so therefore things like discrimination won't be allowed. So the rule nonetheless must be reasonable, and it must be a valid rule. Okay. For example, if there was a rule that says that no, you can't become pregnant here. If you become pregnant here, then you must leave. There could very well have been a rule like that in the workplace, decades ago. But now we know That is the complete opposite now. Now you, as the employer, will get into trouble if he thinks he can enforce a rule like that. So that's the next question. The third question is, did the employee know about it? Was he aware of the rule? Or if he didn't know, could he reasonably be expected to know about it? Okay. Sometimes employees, this is the main thing they say, well, we didn't know that was wrong. We didn't know where to do this or that. So we have to judge that according to reasonableness. It's easy to say you don't know, but your actions will be judged against the standard of reasonableness and will be asked that you should have known. Shouldn't you reasonably have known? Okay. If you are working for a security company where you handle firearms, and one of the requirements of your job is that you at all times must have a valid permit for your firearm, and you've allowed your permit to expire, and you were warned, look here, you know, your permit is expiring or will expire or has expired, correct it, and they give you time, you don't do it, and then, you know, that could be something that you should know. Even if they don't tell you, you should know that, hey, I should have my license updated and be validated. Okay, so there's this reasonable element that is compared to the reasonable behavior of a person. And was the rule consistently applied by the employer? This is another important thing to decide whether you know, misconduct is justifiable. You know, part of the substantive fairness rule, that you can't apply one rule to one employee but not to another. If you apply a certain rule, you must apply it consistently. Okay. So consistently in the workplace is very important, and if you don't apply it properly, or if the employee can show that the employer doesn't comply or apply the rule consistently, applies it to some but not to others, then it is a good reason to show that this is not substantively fair. Okay, and then lastly, they will ask, of course, is dismissal an appropriate action for the rule? Remember, we use a system of progressive discipline, and it all depends, a lot depends on the nature of the act of misconduct. Okay, coming late is an offense, yes, right? It's a reasonable thing not to expect an employee not to be late and to come on time for work. Okay, but it is not exactly the same as assaulting the manager or assaulting somebody or damaging company property or dishonesty in the workplace. Okay, so it's a mixture of things here. Honesty is extremely important, but it may not be such a big deal in certain industries, you know, and in other industries it is indispensable. It cannot be parted with, and if there's even a tinge of suspicion of dishonesty, then, you know, you could be disciplined for it. So it's all a question of the circumstances of every case. And ultimately, if you know, if you've broken a rule that is well known, and you are found guilty of it, or you may admit to it, then the employer, you leave yourself in the employer's hands when it comes to you know, either dismissing you or not. Okay, but naturally, as we will see later when we come to procedural fairness now, and how a disciplinary hearing should be held and the rules that apply to that, you know, that the employee must be given that chance. But this is for now is the requirements, the substantive requirements for misconduct. Any questions on that? No questions? Okay. So for next week, think about that, guys. But before we leave, what would you do if you were an employee? What would you do now to regulate misconduct? What should you do? I'd argue you must do it, but let's say you didn't do it. So let's then just say, what should you do as an employer in the workplace to regulate misconduct and discipline in the workplace? What should the employer do?
May I come in, Prof?
So yes, please do. Yeah, go ahead.
Yes, okay. No, as an employer, to regulate misconduct, it is to develop what is called a disciplinary code, which incorporates, the offenses and the sanctions and the manner how those offenses are dealt with, so that it could be identifiable from any employee and understand what is expected from him or her. And even if he happens to misconduct himself, he would know very well what would be the outcome of that offense.
Thank you. That's good. You see, in employment law and employment law practice, policies, there should be not only a policy on discipline or misconduct, there must be a policy on almost every aspect of the workplace. Right? A policy is basically a rule, a set of rules and guidelines by which the employer will apply certain things in certain situations. Okay? Yes, Grant.
Prof, in addition to what my learned friend said there about the policy on misconduct, perhaps also as an employer, I think I would ensure that I have some sort of proof that the employee is aware and was part of perhaps an induction to understand the misconduct policy to make it easier going forward.
Very good idea. In fact, many employers, when you sign up and you sign the contract of employment, they refer you to all their policies. And it's good practice to, in fact, always give your employees copies of the policy, so that they know where they stand and can never be, raised by them. But as we will see next week, guys, when we come to hopefully reach procedural fairness, we will see now the role of policies in more detail and how important they are. All right. Time is up. I have to go and do something now as well. I want to thank you. And I also want to remind you now that you can book a session with me at no charge and no cost to you for consultation if there's any aspect of the work that you want me to clarify. Terzel Rasmus, are you there?
Hi, Prof. Yes, I am here.
Hi, yes. What happened to you? I responded to your email there, but I didn't get a response. You did request a session, and I did send a response. Did you get that?
Yes, but they asked for Tuesday, and then I emailed
Oh, you
back.
can.
I
Oh, I
make
see.
it that time,
Okay,
and then
that's
I
fine.
can't make it another time. But I think I did private message you. I found you on the system, so I don't know if you got the email.
I didn't get that, eh? I didn't get that, honestly. Maybe if you want to send me messages, guys, relating to this, want to request a session, you can actually get me on this here. Let me just post this here as well. I would prefer that you make use of the link that Adele has put up there, because then everything is recorded, and there's evidence of the whole thing, and it's all in one central area in Microsoft Teams. But those of you who want to get sessions and so forth, you're welcome. Okay, guys. Sure. I'll see you next week.
Thank you very much, Prof.
No problem. Go on, guys. See you.